Hello, and thank you for joining us today for this Introduction to GDPR webinar. My name is Melanie Blackmore, and I'm the Managing Director of Blackmores, and I'm also joined by our resident GDPR and data security expert, Rachel Churchman. So what is GDPR? Well, GDPR is the General Data Protection Regulations. This is a legal act of the European Union with the primary objective of giving controls to people over their personal data across Europe. Now, you may be wondering what effect Brexit could have on GDPR. Well, Brexit or no Brexit, GDPR is coming and will be enforceable in the UK by the ICO, which is the British government's Information Commissioner's Office. Another question that we've been asked is, who does the GDPR apply to? Well, quite simply, any organisation that processes personally identifiable information. So this will affect many businesses across the UK. And finally, how long do we have until the deadline? Well, the clock is ticking, as the deadline is the 25th of May 2018. So without further ado and wasting any more time, I'm now going to hand over to Rachel Churchman to explain all about the GDPR requirements.
Thank you, Mel. I'm going to give you an overview of some of the new requirements of GDPR. Here are some of the higher level requirements now placed on businesses. GDPR applies to controllers and processors. So the controller says how and why personal data is processed, and the processor acts on the controller's behalf. GDPR now places specific legal obligations on the processors. That's for electronic and hard copy data. A significant addition is the accountability principle. GDPR now requires you to show how you comply with the principles, i.e. documenting the decisions you take about a processing activity. And you have significantly more legal liability in the event of a breach. And unfortunately, that means higher fines as a consequence. Data subject rights. Data subjects are individuals who you may hold data for. And they have far more rights under GDPR that you need to understand as a business. There's lawful process, consent, the right to be informed, right of access, right to rectification, the right to restrict processing, the right to data portability, the right to erasure, and just the right to object to how you are processing their data. And we will touch on these elements in more detail later. Accountability and governance. So you are expected to provide comprehensive but proportionate measures under GDPR. And some examples of that include the use of privacy impact assessments, ensuring privacy by design, ensuring you have adequate information security controls, and ensuring that you have taken into account training and awareness within your business. So the aim is to understand where data resides in the business, minimise the risk of breaches, and ultimately uphold protection of personal data. GDPR versus the Data Protection Act. So we're often asked, well, how different can it be to the Data Protection Act? Well, the fundamental principles of data protection remain, but GDPR now escalates some of the requirements placed on businesses. Subject access requests. There's now a time limit of 30 days to respond, and you're not able to charge for that privilege anymore. Governance. There's a requirement for a data protection officer, depending on the size or complexity of processing. However, regardless of size, you will be looking to implement somebody to look after data protection within your organisation. The definition of personal data itself has been expanded. This is in recognition of new technologies, so it now includes online identifiers such as email addresses or IP addresses and genetic or biometric data. Breach notifications. There's now a time limit in force for you to report any significant data breaches. Responsibilities. So the responsibilities now extend to processors. Compensation. Compensation can now be claimed for non-material damage. So individuals can claim compensation for distress or hurt feelings, even when they're not able to prove any financial loss. Data consent. Clear, proactive, positive consent must now be given. And if it's given, it can also be taken away. Penalties. This is one of the headlines that's caught everyone's eye. Penalties now extend to 4% of global turnover, or £20 million, whichever's greatest. The recent Google fine that hit the media in the last week or so would have been far greater under GDPR. Parental consent and accountability. So parental consent is now a requirement. So this affects any business, establishment, organisation that might deal with children 16 or under. And accountability. There are now explicit accountabilities defined. Businesses must be able to demonstrate compliance. Principles of GDPR. So as you would expect, GDPR is based on 6 key principles. This is what you need to be able to prove. Data is lawfully, fairly, transparently processed. Informing data subjects how their data is being used and making it clear who you may share it with commercially. Data is obtained only for specific legitimate purposes. You need to check and document the legal basis. Data is adequate, relevant, and limited to what you need. Only collect what you need. Don't hold data if it's not required. Data is accurate and up-to-date and corrected without delay. You need to have processes in place to respond to data subjects when they exercise their rights. Data is stored in a form that permits identification no longer than necessary. So only hold on to that data as long as you legitimately need it. Do you have a retention policy? Is it enforced? Businesses to ensure appropriate security, integrity, confidentiality. Ensure that you have adequate information security and cyber controls in place. Are they tested, monitored, effective? Subtle changes to requirements. There are some subtle changes to the records you need to retain for your processing activities. And if your organisation has more than 250 employees, you may be required to maintain additional internal records of your processing activities. There's this overarching obligation to provide that comprehensive, clear, transparent privacy policies to people you hold data on. For processing to be lawful under GDPR, you must identify that legal basis before you process the personal data. You need to document this basis. Data Protection Officer. So every organisation with more than 250 employees must nominate a dedicated Data Protection Officer, or DPO. So as well as being suitably competent or qualified in data protection law, the role will also require the DPO to be proficient at understanding IT processes, data security, including cyber security, and any other critical business issues around the holding and processing of personal and sensitive data. Any organisation is able to appoint a DPO, regardless of whether the GDPR obliges you to appoint one. But as a minimum, you must ensure that your organisation has access to competent skills to discharge your obligations. So this can be in-house, or the role of DPO can be outsourced. Positive consent. Consent under GDPR requires some form of clear, affirmative consent action. You can't have silent or pre-ticked boxes anymore, or state that by continuing they consent to you using their data. Consent has to be verifiable. This means there must be some form of record retained of how and when consent was given. Some examples of when this can be applied may be when recruiting new staff. Do you confirm with candidates how you will use their CV, or how long you will keep hold of it, or check that they're happy for you to do this? When obtaining data for marketing reasons, do you tell individuals how you will use that information, or who you may share it with? Do you get their agreement in an auditable format? Breach notification. So there'll be a duty on all organisations to report data breaches to the relevant supervisory authority, the ICO in the UK. And in some cases, you may be obliged to report breaches to individuals affected. For this to be effective, organisations need to ensure that all staff understand what constitutes a data breach, what needs to be reported or captured for investigation. They need to have an understanding of the data breach procedure within your organisation. So what might constitute a data breach in your business? Accidentally sending sensitive data to the wrong person? How many times have we forwarded on emails around an organisation without checking the thread or what's contained within it? Or what about a cyber attack on your payroll data? Notifiable breaches have to be reported to the ICO within 72 hours of the organisation becoming aware of it. If the breach is sufficiently serious to warrant notification to an individual or the public, the organisation responsible must do so without undue delay. The ICO will take a dim view of waiting that 72 hours in those events. A recent example has come to life whereby this requirement failed to happen, and it resulted in a significant consequence to individuals. More than 500,000 pieces of patient data between GPs and hospitals went undelivered between 2011 and 2016, a period of 5 years. A mail redirect service was set up for the NHS for people who may have moved GP or address. Significant sensitive data was sent using this service, including important test results, medical data. The service encountered issues that resulted in the mail being stockpiled in a poorly secured warehouse, with the intended recipients never receiving that important medical data. Under GDPR, this issue would have been reported as soon as it became known within the NHS. Failing to notify a breach when required to do so is one of the likely scenarios that will incur that significant fine. We recommend, if you have an established breach procedure, that you test it to ensure you can meet that 72-hour deadline if required. Right to access. Under the GDPR, individuals will have the right to obtain confirmation that their data is being processed. They have the right to access their personal data and any other supplementary information that you may hold on them. So typically, you should be providing this information proactively to individuals or data subjects. This may be within a privacy notice that you provide as part of your consent process. Right to erasure. This is also commonly known as the right to be forgotten. So this control gives the data subject, the individual, the right to require a business to permanently delete all information held about them on any one of a number of grounds. And you are required to prove that you have a compelling reason to continue to process that data should this right be invoked. And if that request is upheld, you need to ensure that data is removed and that it's removed from anywhere where you may have transferred or passed the data onto a third party. And you need to make every effort to make that happen. An example commonly used today is when someone has signed up to receive your email newsletter. They can also retract this consent, and you must remove their details and not send any more information. This is not a new requirement. Individuals also have the right to rectification. So should the data you hold be incorrect, inaccurate, incomplete, individuals are entitled to have that personal data corrected. They also have the right to restrict processing. So you may be entitled to hold their data, but you will be restricted from processing it any further. So it will be essentially frozen within your organisation. Data portability. So a data subject shall be able to transfer their data from one electronic system to another, and without being prevented from doing so by the data controller or processor. So examples of this already exist today. You may change your utility provider or your bank, and the two organisations are expected to work together to transfer data without any adverse effect to you as an individual. But do your systems allow for this? Transfer of data. There will be restrictions on the transfer of personal data outside of the EU. And this is to ensure that the level of protection afforded by the GDPR is not undermined. So you will be expected to ensure that a sufficient level of protection is in place before you transfer that data. So sufficient level means the same or greater than that required by the GDPR. So hopefully that's given you a flavour of what GDPR is about. I'm now going to hand you back over to Mel, who will be able to chat through the Blackmores approach.
Right, thanks, Rachel. So at Blackmores, we've been implementing information security standards and data protection controls for over 10 years. So this isn't a new area to us, which is where we've been approached by a number of clients. And what we've done is over the last few months is developed more structure around about the deliverables really to assist our clients with complying with GDPR requirements. And what we've done is we've actually based this on a framework which is an personal information management system framework around the principles of the British standard BS 10012, which has been around for a couple of years, but it's actually been reviewed and updated to be aligned with GDPR in 2017. So this is perfect timing for us to basically align our route to compliance with this British standard. So the first thing that you need to do within your organisation is to identify the person that's going to be responsible. Who's going to be your data protection officer? So you may already have somebody who's been designated this role in the past when you've been registered with ICO for the Data Protection Act. And it may be that that is still the same person. However, what you do need to take into consideration is whether this person is also familiar with IT security controls, such as cyber security, which would be helpful in this position. And we also recommend, ideally, having champions across different functions across the organisation, because undoubtedly, they'll all handle data in some way. So it's great if you've got some champions across the organisation to help you to implement any controls required and to clearly define those roles and responsibilities. The next stage is to identify what information we're collecting as an organisation, how we process it, and how we store it. In order to be able to do this, we've created a GDPR questionnaire which helps you to understand all of this information and helps you to create a privacy impact assessment. Later on, Rachel will explain a little bit more about the privacy impact assessment, but ultimately, it's about identifying where this information is coming from and where is it going. And you need to be able to map that out somehow. And we recommend using a data transfer matrix, which very clearly identifies where your information is coming from, where it's going. And Rachel mentioned earlier on about having justifications for holding on to information and only holding on to it for specific timeframes based on legitimate reasons. And these could also include legal reasons. So you do need to identify that within the organisation, so you can provide a justification if asked. Once you've gone through this exercise, it's then useful to be able to look at the risks associated with that data and how it's handled. You need to look at the controls that you've currently got in place to see if they're adequate to protect that data. So by completing a risk assessment, you'll be able to look at priorities and risks across the organisations. From that, you can develop certain documents. Now, these requirements aren't necessarily mandatory, but we're just recommending them based on best practice and based on our experience of information security standards and controls to comply with statutory and regulatory requirements. So I'd recommend that you have a retention policy that clearly identifies how long you're keeping that data for. And then that can be clearly communicated to employees. Where necessary, having operating procedures for the control and the protection of data, which could include consent processes, security controls, disposition and transfer of data when requested. Now, some organisations that have quality systems in place, compliant to 9001, may have some of these things in place under control of documents and records, and others that might be certified to ISO 27001, the information security standard, will probably have some of these controls in place already, such as data backup, encryption of data, and all those sorts of controls. There's generally good practice when it comes to information security. So it may just be a case of tweaking the current processes that you've already got in place. Rachel mentioned earlier on about responding to breaches and the time frame that you've got, which is 72 hours. Now that is pretty tight within any organisation. So it's really important that all employees understand that if there is a security breach, how to act. So without having a formalised procedure in place, it's going to be pretty difficult to be able to do that. So we strongly recommend having a breach response procedure. So if there was any potential breach and it wasn't reported in time, we can say, well, these are the procedures that we've got, this is what we've implemented, and it may just assist, by having that procedure in place, but it certainly will help with the communication and compliance to GDPR. Many organisations already have a data protection policy, so it's just a case of reviewing and updating this to make sure it's aligned with the GDPR requirements. So the next stage is to communicate these policies and procedures to all relevant stakeholders. So I'd recommend having a communications plan in place over the next few months or so until the deadline of 2018 in May, and ideally beyond that, because it goes without saying that changes that are put in place over the next couple of weeks will take more than a couple of weeks to actually be cascaded down throughout the organisation and ensure that you're fully compliant. So it's best to have an ongoing communication plan, possibly over the next 12 months, to ensure that everybody's clear on roles, responsibilities and controls for data protection. So this could include training and awareness. And obviously, businesses evolve and change. You'll be handling different types of information in different ways. So it's really important to review this process on an annual basis to identify if you've got any new or changed processes for data handling. So Rachel is just going to give you a bit more information about the privacy impact assessment.
Okay, so conducting a PIA is not a legal requirement of GDPR. However, the ICO has promoted PIAs as a tool to help organisations comply with data protection obligations for a number of years. And in the event of a significant breach, the ICO may ask a business whether they carried out a PIA. This is because they understand that a PIA is a tool to help identify compliance with GDPR or compliance obligations. It helps a business to understand whether personal data is transferred, processed, handled, stored, or passed on by the organisation. And an effective PIA will allow organisations to identify risk and implement those controls. But it's important to remember that conducting an effective PIA involves working with both internal and external stakeholders to identify and reduce those data protection risks. In some circumstances, the GDPR regulations do mandate the use of a data privacy impact assessment as a way of ensuring privacy by design. So there's benefits of conducting a PIA. Not only is it the best way to start ascertaining compliance to the regulation, there are a number of benefits. It should improve transparency and make it easier for the business to understand how and why information is used and held. It will help to ensure that problems are identified at an early stage, and when addressing them can often be simpler and less costly than after a breach. It's going to help you understand your customers by involving them in the process. And ultimately, it's going to help produce improved policies and technical controls. So hopefully we've helped you to understand the main requirements of GDPR and how Blackmores can assist you on this journey. But I'll now hand you back to Mel for some closing comments.
Thank you. So if you're looking at where to begin with your GDPR journey, we have got a number of options if you are interested in having some support with this, which includes GDPR awareness training. So you might want to inform the leadership team within your organisation on the main requirements of GDPR. We're also going to be turning this into an e-learning course, which will be available at the end of July. One of the things that we've been doing recently is a GDPR workshop, which is a very interactive session whereby we help you to understand your data management and controls by basically facilitating that privacy impact assessment process. Some organisations may have already done this, which is great, but they might just need a little bit of help tweaking policies and procedures. So we can also come in and do that, whether it's one day or a couple of days. That shouldn't take long at all to do that. And for some clients, we're actually providing a GDPR compliance fast track program, which covers all of the above, but we also help them to understand their data analysis, controls and implementation as well. And then finally, for those organisations that are looking at GDPR software to assist them on their journey, particularly for larger organisations that need to process data sets, data types, and need assistance with implementing controls around that, we can also provide software solutions in relation to that. So thank you very much for joining Rachel and I. We hope that this has been a useful 30 minutes of your time today. And if you have any questions at all to ask regarding GDPR or our services, then please feel free to contact us and we'll be happy to assist. Thank you for listening.